Okay, so welcome back from the lunch. We have in front of us almost 1 hour and a half for the last session of this conference. And we have, for this session, quite a high number of speakers. And we also have a heavy responsibility in this session because it's the closing one. It's the session where we have to think about university for our kid. University for the TREIO project. So what will he be doing in his future? She, he, okay, doesn't matter. It, it's an it. It's a need to be correct. We at the beginning, yesterday morning, I shared with you some keywords. At the end of this session, I will improve the list because a lot of challenges have appeared today between between the sessions. And so our responsibility will be to understand together how we can go forward, which is the future for our efforts, and how can all these results be transferable in other contexts and also in the European Investigation Order itself. The first speaker of the session is a friend of ours, a friend of our projects. She has always been cooperating with us, giving very useful feedback. So I'm very happy to have today here with us Teresa Magno. Teresa is a judge assistant to the national member for Italy at the Italian desk of Eurojust. And she will set the starting of the thinking process about transferability and future for TREIO by giving a speech on digitalization of justice and the role of training. So, Teresa, you have the floor.
Many thanks, Mariangela. It's me, the one who has to thank you for being involved in so many interesting initiatives, and TREIO is just one of them. So she authorized me to go wild in this session, and actually I try to think of all the possibilities that TREIO can have in front of it. So yeah, let's begin. Shall I use this one?
Yes.
Okay, but the right way. You are right. Okay. Okay. So first here, and then I see it here. Thanks. Okay. So.
Switch it for you.
No, I can do it. Thanks. Thank you. I have prepared quite a long presentation, so be reassured I'm not going to take too much of your time. So in case you are interested, you can always refer to the presentation. But I try to really think of all the possibilities that TREIO may have in front of it. Because this is, in my opinion, a very meaningful and valuable project that has to be really put into practice. And I will talk briefly about its specificities. And I will relate it to the legacy of the pandemic, as far as we are concerned. We judges and prosecutors are concerned. So I will make reference to this, how this can impact and how it's important for us to reflect upon the security of the means of communication. Digital court proceedings is an issue as well. So reference will also be made to the regulation on the digitalization of judicial cooperation. I work at Eurojust. It's my 6th year there. And I'm ready to come back to court. So I have quite experience. And we have a long path before us. Anyway, so electronic evidence as well. And I hope to have just a little bit of time to go more into depth as far as the evaluation of electronic evidence by judges and prosecutors is concerned. What I mean is that judges and prosecutors have not to be influenced in the evaluation they make, but they have to have the necessary instruments, tools, to make the proper assessment of evidence. So brief reference will be made also to the artificial intelligence, how this is impacting already cross-border digital criminal justice, but also criminal justice as such. Yeah, I can do it. Thank you, anyway.
It's automatic.
Yeah. I saw you doing that. No, it's okay. So I said that TREIO is a very valuable project. It's because it comes out of 3 different projects, but the unique feature is that it tries to combine the legal and digital aspects, components. And judges and prosecutors have, are more familiar with, I would say, on average, with legal topics rather than with digital topics. So there is a gap, and this gap has to be filled. At the same time, TREIO as instruments, as tools that could be put really more into use. And by this, I mainly refer to the simulators that are part of the TREIO. It's quite relevant to have such a tool because it mirrors what can happen in reality. It's thought-provoking and is something that can provide useful knowledge for us. And also, what has to be underlined is that the needs of the different stakeholders are taken into account. It's something that we should not take it for granted. When I looked at this project, I really thought that it's a wow project. It's not because it's you, we are friends, no. It's because really it has lots of content. Do not underestimate it. Not at all, because everything is there. If you really want to put it into practice, this can make the difference. You already know that only 5% of the judiciary who deals with judicial cooperation in criminal matters are covered by training at home. So it's just 5%. And I don't know what Jorge will say about this, but working at Eurojust, you really see the shortcomings. So it's let's say, a kind of privileged position where you know what has to be tackled. And at the same time, you are aware of the complexities of the problems. So I think that I can, now, I can go also very granular, talking about problems, but the complexities is also overwhelming at the same time. So this is why I think that such a project can really be beneficial. So it's just a first step. So it's not an arrival point, not at all. It's just the first step. But maybe sometimes the first step is the harder one. Let's hope it's like this, which means that the most difficult times are behind. I hope that for you and for us as well. So you are dealing with so many issues in this project that, for me, what is underlined is the possibility to cope with different issues, but also unprecedented ones. And this is a project that allows to also cope with difficulties. We are not talking only about legal difficulties. We are talking about also difficulties to approach new realities. So it's the difficulty of the judiciary to approach the digital way of working, the digital way of conducting trials. It's the necessarily our categories, our legal categories, will have to take into account the tool we are using. It goes without saying that there is kind of cross-fertilization. We cannot be fixed in our legal positions. We will have to take into account that changes, amendments, integration have to be made by ourselves. And this is also a process of awareness, of acknowledging needs that maybe we are not even aware we have. It's a little bit the discussion we were having at lunch, but I'm not going to talk about this. But anyway, everything is very much into evolution. And I think that your project and also the possibility to work at a European agency as Eurojust give us the a little bit of an pursuit of an idea of what's coming. But the reality is different. The reality is colleagues trying to cope with the difficulties that come from digital systems that are not adequate to the needs. I'm sorry. I'm talking to you. I'm so sorry. But that's the reality, because he works at the infrastructure system in the Ministry of Justice, so he knows, I mean, all the shortcomings that we have to deal with. So the reality is very much different. The reality is mirrored, for example, into the judicial cooperation requests we receive at Eurojust. They ask help for, I mean the colleagues, judges and prosecutors. So prosecutors of first instance and judges even from the second instance, from the appeal court, they ask for help because they think that having in place a video conference abroad, it's a hurdle. Yes, it's a hurdle. There are so many difficulties that they have to ask us, Eurojust, who is meant to work with the most serious investigations and crimes committed in Europe, even to organize video conference in proceedings for not so serious, apparently serious matters. How come? There are so many difficulties. So it's legal difficulties, it's infrastructure difficulties, it's also, let's say, kind of approach difficulties. And a lot has to be done, but and the needs of reality are mirrored, I think, in the communication that was issued by the Commission for the strategy on training from 20 to 24. It's almost everything there. But there is a gap between what we are, let's say, trying to achieve and the status quo. And yeah, so let's. I will try to go a little bit more quicker than I thought. So
take your time.
Yeah, so I can go to this one then. Okay, so judges and prosecutors are dealing with digitalization. Not necessarily we are all equipped, well equipped as we would like to be. It means that there are difficulties and hurdles such as the one that's linked to ensuring that our communication is secure. I don't know how it is in your jurisdictions, but in mine, sometimes we do not even think that if I address an email to Mariangela, for example, I would be hacked or intercepted, or my system, the system I use, is not so resilient. I simply do it. And there are so many issues that are related to it that, I mean, we have to take into account, but sometimes we are not even aware of. Why? There are so many reasons that I'm not going to dwell much in it. But this is the security of the system is fundamental. It's fundamental when we write emails. It's fundamental for the lawyers to have access to the judicial files. It's fundamental when colleagues send to Eurojust elements of proof in proceedings, in criminal proceedings. So this is something that we should be really aware of, but this is also relevant for video conferencing. Why am I saying this? I'm not saying that judges and prosecutors have to become IT experts, no, but we have to have minimum knowledge of the issues, because these issues will allow us to work in a safer environment, to reduce the risks that we are able to reduce, and also to be, let's say, more critically equipped to assess the complexities of the digital realities that's before us. So you know that regulations are in place that are going to support this process of digital change, and I have mentioned them in the slide. So now we can go to the second broad picture slide. So it goes without saying that we have to master these new systems of communication, and we have to be put in a condition to be able to do so. So this is why training is beneficial. So training is necessary also for the change of mindset. Let's say a moderate one, just to be realistic, but this is necessary. This is a change that has to be brought to our way of working. So this is linked to efficiency also of the court proceedings. These are there are no empty words. It's the way it should be. So the digital tools in court proceedings are fundamental, and we will necessarily have to use them because, as I was briefly saying before, we have supranational investigations in place. We have so many judicial cooperation instruments, but as far as the developments and the trials are concerned, we are a little bit behind. It's as Maya was saying, talking about the video conferencing and the use of EIO. It's true because it's such a hurdle, but at the same time, we are convinced that a safeguard mechanism should be put in place in order to balance efficiency, speed with respect to fundamental rights. It's easier to say than to do, of course. Another issue that derives from trials being even more and more international is the service of documents. The Commission has already addressed this. But really, at the desk, we have been overwhelmed by requests to LOR, rogatory letters, to ask foreign countries, member states, colleagues to notify summons, because this is necessary for the proceeding, at least for the Italian proceeding, to go on. And there are so many difficulties related to it. So there should be more of an interplay maybe between the police force and the judiciary, but still, the number of requests that are sent, at least from the Italian courts and prosecution's office abroad to have acts notified is huge. And it's cumbersome. So again, this is food for thought. How can we address this shortcoming in an effective way, in a more effective way? We will see. Also, specificities of the criminal phenomena have to be taken into account. What do I mean by that? Training is necessary to get a more in-depth view of new kind of criminalities that are related to cybercrime, but also to terrorism. So there are new criminal phenomena that are very much related to the use of technologies, and it's something that we can't ignore, absolutely not. It's something that, on average, the judiciary will have to deal with. So I don't know whether you have had already conversation with colleagues saying, look, I've never had any issue with major cyber crime investigation, whatever. So I'm, let's say, a little bit at the side as far as the topics are concerned. Well, I don't agree with this, because in any investigation, in any proceeding, the electronic evidence will be relevant. And are we sure that we are really properly equipped to evaluate this evidence, this kind of evidence? I don't know. This is why also, such a training is important. But on the other hand, TREIO has been proved to be valuable in the EIO training. That's why TREIO. But it's just the first step. We will have the European Preservation Production Order. We have the MLA. We have so many additional instruments that share the same difficulties. So TREIO has a methodology that's universal. By this I mean that you can apply it to any instrument. You can follow, let's say, the same flow, the same instructions. And the simulator is good. for example, because it's something very tangible, it's something that you can use, it's immediate, it's very easy to understand. So it can be really, it can make the difference, I would say.
Taking notes.
So there are so many relevant topics that you may want to add, but this depends on the scope that, I mean, you are going to decide. You can reflect from the specificities of electronic evidence, but also to the impact of AI. And there is something that, well, for me, it's super important, is the handling of electronic evidence, the life cycle, and the chain of custody.
Yeah. Chain of evidence.
Chain of evidence, yes. This is something that really makes a difference. So think about a huge amount of evidence that has been collected during the investigation, and that at the end, it turns out that it's not admissible in court. Complete failure. And we have so many thorny topics now. Think about the interceptions, these huge investigations that have been brought along with data that have been, let's say, intercepted. I don't want to go into specifics, but what I'm really concerned and I want really to grow awareness about is we have to be sure that the evidence that's collected in the investigation phase is something that can be really admitted and used in court. It's not, you can't take it for granted because maybe you have had an authorization abroad by a judge, judicial authorization, that automatically the evidence collected there can be used in courts. That's going to be very sensitive. Of course, I'm talking about the crypto phones platforms. So, and I guess that it's not only in Italy that this has been a really relevant topic, and we will have next month. It's expected next month the decision of the joint sessions of the Court of Cassation on this. So this will be tranchant. That's the ruling. So we are really eager to read the judgment. We will see. So handling of electronic evidence. Yeah, chain of custody is fundamental. It has to be. It has to remain unbroken. Why am I insisting on this? It's because of experience. Because I see that sometimes there are issues that are overlooked because they are not perceived. So the relevance is not perceived, or simply is disregarded because there are so many issues that can't be tackled that, let's say, that a certain level of risk is accepted. And the reasoning behind is that then we will see what will happen in court. We will see. So authenticity of evidence and preservation of evidence, all the precautions that have to be taken, yeah, they go with it. So for me, this is a super relevant, I would say, topic, because I see the impact, because we have worked so much resources has been put into it that we have to have it right. And the chances of having it wrong are very high. So, yeah, we will see. So, what is also relevant is for us, judges and prosecutors, to understand the need to have tools recognized by the forensic community in place, because this makes us sure when we have to recover electronic evidence from the source or the media. We have to be proper safeguard in place as far as the security of the systems, the security of the tools, the security of, I would say, the IT infrastructure itself. And maybe you come from a different situation, but in Italy we are struggling with it. We are struggling to have secure infrastructure that covers the whole country. I do hope that we can achieve it. Yeah, I know you are doing your best, but yeah, that's what is behind, because it's in front of us. We have high objectives that we have to meet that are set by the European institution, the European instruments. And this is our future. This is what we have to achieve. I do hope that we can achieve it, because otherwise we will be left out. And all the systems is based on building a proper infrastructure, on having proper awareness of the downs and pros. So, yeah, I really hope that we can meet these high expectations. But what I'm saying here is that we also have to take into consideration that the level of problems colleagues face is a little bit lower than what we are talking about. And if we want to build a proper house, we have, as we always say, start from the first bricks. So let's try to have this first bricks in the good position and have good qualities of bricks. Okay, so again, I think that I have already mentioned it, so we can proceed, but this is something that I would really emphasize, the chain of custody, fundamental. And again, I don't know what the new TREIO will look like, but again, the foundation for evidence, for assessing evidence. What is the evidence? How can evidence be approached? It's fundamental. Documentation is another issue, which is also underestimated and overlooked, because not always careful documentation is carried out of the steps that have been taken. And I've been very surprised in the cases where it was really done properly, because this is the exception and not the rule. So again, this is something that we have to work upon, and it's related to fair trials and respect of fundamental rights. And also we have better chance to get a proper result sooner and with less effort and resources. So validation, again, goes in the same direction. And then we come to the last slide. AI. I don't know how it is in your jurisdiction, but we are pretty familiar with ChatGPT, as we were talking a lot, but that's where our knowledge almost stops. Okay, so this is something that you may want to consider in such an advanced project, because we, judges and prosecutors, have to be more aware of what is AI, what is an algorithm, what are the risks related to this application when it comes to trials and investigations. So it deals with the awareness of what is implied by biometric recognition and forensic analysis. I'm not saying that we have to become forensic experts, no, but we have to have the tools to assess, properly assess the evidence that is brought in front of us. This goes with developing critical expertise and enlarging the expertise that we already have, for example, as judges and prosecutors when evaluating scientific evidence. So we have also to recognize needs that are embedded in the use of this new application, and the training is the best place to do so. I'm also thinking about simulations, because it mirrors all that can go wrong, and it's something that you can immediately grasp. The risk is there if you use a simulation, which can be also like kind of game. Then it's so much. It's clear. It's there. I mean, it's the same thing happens with machine learning. You know that there are those systems that have been fed with jurisprudence, with decisions that came out, and the outcome were decisions that that were biased. And the judges were the first ones to recognize, look, this is a biased decision. Why? Because the data that have been inserted in the machine learning tool, they were biased. Awareness of deep fake. That's what I was also making reference before. So we have a video conference in place, and we are sure that, for example, I'm talking to Maya, but Maya is not Maya. Maya is the artificial intelligence. Okay. We want to prevent this. So we have to be equipped both with, from the legal perspective and the digital perspective. Algorithm. So that's another topic. So I simply made reference to some questions that we might want to ask when we have to assess the nature of the evidence of the outcome of the use of algorithms. What does it mean? Are they weak? Are they reliable? To what extent it's, for me, beneficial to use it? To what extent is it's dangerous, I mean, to use it? These are difficult questions, and I mean, no easy answer can be provided to it, of course. So last slide, conclusions. So what can be the new TREIO 2.0? Well, I don't know. But I know that there are so many topics you can tackle that really it's up to you. But again, these are all possible areas that you might want to explore, but you have, I would say, a methodology embedded in the TREIO, and you can use it for whatever instrument you want to. So it's up to you. Thanks for inviting me.
Thank you very much, Teresa. And I forgot to say that as a friend, when I invited her, I said, okay, please tell me the truth. Tell us the truth. So be honest as a friend. Thank you very much. And your words were music to our ears, because we don't have to forget that we started working together in the Evidence Project. And the main core was to treat and to deal with electronic evidence. But times was not mature at that time. We were pioneer in a jungle which has no kind of inhabitants. There were no humans, no animals, nothing. It was like a desert, and we were pioneer in a desert, and then we gave up with treating with the electronic evidence. But we have all there, because our results of the evidence are ready to be put in place at this moment, which I think it's now the call for what we have realized 10 years ago. Okay, so I will not take any time. Is there any question for Teresa? Rosario, you have your... You want to make a question? No, you just forget? Okay.
I forgot it up, but you asked me for a consideration, and I put only one brief consideration about forensic analysis, that I wish that forensic analysis will be one of the tasks of the public bodies, of ministries, and for providing to the judiciary authorities, because it's a wide habit for judiciary authorities to use external technician for forensic analysis, and above all, external software to manage this topic. It would be a better thing to have some internal resources for leading these cases, important cases, just to ensure the genuinity and the trustability of the instruments. Thanks.
Okay. His contribution to our discussion, I think it's important because he's the one that can tell us and communicate to us which is the role that the European Commission assigns to the training, and mainly in the judicial field. So, Mr. Prostulski, you have the floor.
Thank you very much, Maria Angela. Thank you for this introduction. Good afternoon to everyone. Indeed, in my intervention, I will zoom out a bit. I will not be discussing that much about TREIO Project, no European Investigation Order instrument. Of course, I will use it as an example of some points I will be making in my intervention. But as I said, I want to zoom out to present to you the frame under which this project has been implemented, supported by the Commission. So frame or the strategy of the Commission on judicial training. So what we believe is the role of the Commission, why we are active in the area of judicial training, what we do, and what is more important, what we will do. And it's important to say now, already at the outset of my intervention, that it is all very much related with the digitalization. My team on judicial training is a part of the bigger entity in DG Justice, which name is Digital Transition and Judicial Training. So you see, it is seen in our structures even, that there is a link between the two, that the digital transition is coming to the judiciary. Digital justice systems are emerging, are being built, but require more and more focus. And training is a tool that can enable it. So that's why we work together in the same entity on both digitalization of justice. So it is with this unit of mine, was the author of the digitalization regulation that has just came into force last week, was adopted in December, and the training is handled by us as well. So you see this link. So as I said, I will zoom out, but not forgetting that we are here at the TREIO conference. What is the role of the Commission on the EU? Of course, we have a competence in the treaties to provide the support. So it's a quite light competence. We cannot impose member states to do something, to train this way, this person, etc. We can only provide a support to judicial training. And how we do it, it is written in the European Judicial Training Strategy that Teresa, you have mentioned already, that is setting the objectives. And the current strategy is for the years 21-24, clear, coming to an end soon. And we are now drafting the next strategy. But already in this one, that we were drafting before the pandemic, so before this big trigger to the digitalization of justice system, we knew that digital is coming. And that's why you can see in the strategy amongst its objectives that one of them, next to the key objective, that was the rule of law, to help national member states to adhere to rule of law. And it was obvious why in 2019 we were drafting the strategy that way. I'm Polish Dutch by origin, by the way, to let you know. And rule of law was, of course, the topic number one for us then, but number two was digitalization. And we said that there is a need to provide justice professionals, and it's a quotation from the strategy, to embrace digitalization and the use of AI in their daily work. And our strategy has three aspects that will remain as well for the new strategy. It is important to mention them, because we have to remember it's not only about the tools. We talk here about the tools, about the video conferencing, about the investigation order, about the procedural tools that we professionals, you professionals, are using daily. And this is one aspect. Indeed, that is becoming digital. That requires training because that requires new competencies of the professionals. But there are two more aspects. So the second aspect is the substance. digitalization, development of digital technologies are impacting the substance of the cases that the professionals are hearing. Even if they're hearing them in a traditional manner, they have to understand the substance of their case, that it is impacted by what has happened out there in the real world, how the crime was committed in a digital way that you, Teresa, mentioned, not to give more examples. And as a third dimension, when all is being digitalized, we cannot forget about the adequate protection of the rights of individuals, about the need to adhere to the fundamental rights. No matter if we hear a case online, in person, the same rights must be secured. Individuals have to have the same right to access to justice. And we know that having the justice served electronically poses some challenges here. So we cannot forget about those three aspects. It's not only about the tools that we are using. It may be most obvious, but we cannot forget that. And so these three aspects are outset in the strategy as those that require new competencies that must be built by the judicial training. But it's easy to set the objectives, and it's easy to say, member states do it, training providers do it. Commission is trying to provide the support in doing that. What is it? Of course, I guess if I asked you what is it, 99% would be money. That is the financial support provided by the Commission. And it's a fact. We have a budget, it's not a high budget. Me, with my team, we have for 7 years, for current budgetary perspective, we have only 110 million euros to support judicial training with. It's not much. You know very well the budget of your project. You know how expensive the training, especially such a specialized training like this project delivered, how expensive it is. So the money are not huge. We expect it much higher for the next MMF, so the next budget of the EU from 2028. For us, it's tomorrow already. I know it's still some years, but the Commission is working on it. So this is the one way, but not the only way. Commission also provides support by trying to trigger the national European stakeholders to act and to deliver, to discuss who needs what and to deliver it how. Few examples, and I come back to TREIO. TREIO is the first example of the financial support. That is a project that has been selected by us to receive a grant from the Commission to be implemented a long time ago. It was 2019 call before the COVID that we granted TREIO project. Commission is publishing every year the call for proposals. Every year we launch the call asking national entities, please design a project, propose something we want to finance, something that is relevant, needed, of quality. By the way, maybe it's too late now because the current call is open, deadline is 21st of March. So if I trigger you to think about the project, you don't have enough time to design something. But it's still open, 21st of March is a deadline in the current call for proposals. There's another couple of millions of euros that we want to disseminate among the projects on diverse topics. You know better what is needed. You have to fit within our objectives, but you have to prove that you've identified the needs and you know how to answer those needs by the training. And such calls are opened annually. This December, we expect another call to be open, and et cetera, et cetera. And priorities differ, and they shift towards digitalization. Already this year, priority is to build digital capacity of justice professionals. This is the main priority. Unlike it was in 2019 when we were applying and we have to cut through the projects on civil law, criminal law, fundamental rights. Now the main priority of our call is to build the digital capacity of justice professionals. Another examples. Last April, 23, we had a conference on how to build the right skills of professionals to embrace digitalization of justice. Again, Teresa, you were a speaker over there. We had nearly 300 stakeholders being present, and with tens of workshops, we were discussing those aspects on what kind of competencies are needed to handle cases where substance is digitalized, to use the tools. We are also discussing the digitalization of methodology of training, which is still another topic. Also touched by TREIO simulation. TREIO simulation tool is an example how the training can use the modern IT tools as a training tool. Another example is European Training Platform. We have such a platform that is a kind of depository of what has been produced under diverse projects. You here focus on TREIO, but imagine every year we finance many such projects. They have many websites where they advertise the outcomes. They come to an end, the websites are forgotten, money are lost. ETP is the platform where we try to upload all valuable resources that can be used independently by the professionals after. And here is maybe the first attempt of mine to answer your question, what's the next step for TREIO? Anything that you identify as of quality and that can be useful for practitioners and used by them independently, although project is not pending anymore, can be uploaded over there. And we are happy to have it there. And the last example of our financing is EJTN. It's a network of training providers from all EU member states. Some of you might be aware about EJTN. Of course, they are financed by us from our grant. And they deliver a lot on AIO as well. They can follow up some of your outputs as well. We cannot underestimate the importance of this network in the judicial training sphere. And all these tools must be used. Because the fact that we launch the call, we give the money, will not change anything until we have a good projects, proposals, and a good implementations done by you. And it's needed. Why it's needed? I will share with you some statistics now. Each year we publish the European Training Report saying how many people are trained on EU law, which area of law, which professions, etc. One of the things that we assess is what is the percentage of the training delivered by whomever, national providers, European providers, financed by the Commission or not, everything is counted. And what percentage of this training related to EU law was focusing on digitalization. The outcomes are a bit terrifying. Separately for the initial training for future judges, future lawyers, future prosecutors, only 5% of any training activity that was delivered in relation to EU law was related to the digitalization or AI. 6% of initial training activities address the issue of IT skills using the tools. 5-6%, not much. Continuing training of sitting judges, working prosecutors, lawyers in service. Less than 2% of their training activities address digitalization or AI. It's a bit better for IT skills, 18% address the IT skills. So here there is a bit of movement. But this data shows that it's critical to start now investing in the training on these digital capacities of the justice professionals. And now I turn to the future. And that will be the key objective of our new strategy that will be adopted by the new college next year in 25. We don't know yet for how many years. It depends on our new commissioner. We don't know who will be. We'll see in the autumn. But we are starting to work on the new strategy. And of course, it will be part of the bigger strategy to digitalize justice systems that is being worked on. And the overall objective will be to use at max the potential of digitalization in improving service of justice. Because digitalization is not objectives in itself. We need to use digital tools to make the access to justice better, to make the service of justice for citizens better. Not just to make it digital because it's fancy, because it's modern. And that's not our objective. And the main key aims that we'll be trying to achieve with building or supporting to build these digital justice systems in all EU member states will be to improve efficiency of justice. Things are happening faster and easier. Secondly, to make the access to justice easier, more equal to everyone. And remember that sometimes if it is the access to digital justice, it's not more equal than traditional one. We have to be careful about excluding some from the access to justice. And the third one, we believe that digitalization will help to improve transparency of justice being delivered. And all that is framed with the need to safeguard the fundamental rights as enshrined in the European Charter of Fundamental Rights. So in short, the vision of the Commission that is being drafted is that by 2030, every citizen has a single access point online to take part in to initiate or take part in judicial proceedings, by the way, using his or her ID card. That's the idea. Are we far away? We are, and only 6 years ahead. So it's quite ambitious. And training is named a supportive environment in the process of achieving that goal. So we want to upskill all the justice professionals in the implementation of the measures that we will be producing. I guess you are aware how much the Commission will produce in the coming years on digitalization. Digital regulation was mentioned here, but this package of digital regulation and directive is just a frame under which in the coming years my unit that I work for will produce 24 instruments. Each of them digitalizing one of the existing 24 instruments of judicial cross-border collaboration in EU. It will come in the years to come in several batches. It has to be implemented, applied, known. Obviously, it requires training. But when we identify what this training environment should mean, it's not only to train on substance of these instruments, but also to impact the mindset of practitioners. Because we can do whatever we want. But if a judge, a prosecutor said, I like my paper, I like my pen, and I like to see people there, he won't achieve much. So we have to invest a lot in the changing of mindset. It will not come by itself. It will not happen by itself following the developments around. So as I said, this will be the objectives of the next judicial training strategy that will be in force from 2025. It's being still a work in progress. And of course, digitalization will be the key objectives with these 3 aspects that I've mentioned. And we'll be going into details who needs training, because we discussed here a lot of judges about the prosecutors. But I haven't heard, at least I joined very late only today in the morning, but I haven't heard the court staff being named as the staff of the prosecutions. We have this reflection, even more in civil justice area than criminal, that the court staff will be more and more important to implement it all. So who? What should be trained? My colleague Maya mentioned before different issues, and you said you don't want to be pessimistic, and there were the technical issues, legal issues, but I would add more issues to that. Obviously, technical issues require technical training. Legal issue required training of law, but there is more. Let me use one example. I hope you know the term judgecraft, craft of judging. So apart from having a knowledge about the procedure, substantive law, we have to know how to work. Part of it is assessment of credibility of the witness, for example. Imagine how much of new competences every judge needs to start assessing the credibility of a judge, of the witness that is on screen, not in the courtroom. I remember when I was years ago trained to be a judge, I was trained how to assess credibility by the body language, by the behavior, but everything that we will lose online. This is just an example of the third aspect, apart from techniques and the law that is changing. And of course, the last thing that we'll be analyzing would be how. What are the training methods? Can we move more online? What we will lose training online exclusively or mostly? To what extent we need still in-person training? What kind of training methodology is needed? And then let me conclude it by coming back to TREIO. I don't know the outcomes. I've heard a lot of enthusiasm here in the room today, as well as my colleague from the Commission who was speaking here yesterday. But we are waiting your final report. We'll be reading the report. We will see what is the outcome. But maybe the TREIO will be kind of the role model how to train, whom to train, with which methods to train, and what objectives to assess. It's one of the first projects that we had under our course on digitalization. And then maybe it will be the one that will pave the way for the others how to do it. But in my last sentence, I will say we can only draft our objectives, give the money, but it's you who have to apply for the grants, deliver them, implement them. Without good proposals, there will be no good training. The Commission is not a training provider, just a facilitator for that. And we are happy to have this role for the years to come. Thank you.
Thank you very much, Mr. Prostulski, for having shared with us the position and what the Commission thinks about the training. It confirmed partly what we have already in mind, and you open up new windows, I would say. So we will treat with that after the reporting, of course, and after the ending of this project. Okay. Now is time for two of our trained, I would say, from Finland. So we have in the room Aki Heitanen, and we have online Ivari. Is Ivari already there?
Yes, hello. Can you hear me?
Thank you. Hello, hello, hello. Thank you for joining from Finland.
Yes, pleasure to join you.
So both they are part of the Ministry of Justice of Finland, and they have taken part to the training, to the TREIO training. So we are happy to have them here and to them to share with us what do they think from the outside perspective about the training. You have the floor. Ivari is the first, and then you, yes. Aki comes.
Yes, thank you. Hopefully you can see my screen and the presentation also there in Brussels. So yeah. I will start, and then Aki will go more specifically on our thoughts on the way forward, and well, obviously I work in the Ministry of Justice of Finland, and as my colleague Aki works, and that is also the perspective that we have on TREIO, and also on the digitalization of cross-border judicial information exchange, and I have to ask, do you see my screen in the conference room?
Alex, sorry. We saw it before, and now we don't see it anymore.
Is your...
Yes, Ivari, we saw it before, but now I don't know what happened.
Okay,
you stopped
I think,
sharing.
Yeah.
Okay, now we see it again.
Okay, now you see it. Great. I think I had some type of technical difficulty. Sorry for that. Yeah. So to sort of set the stage on our presentation. This is the way we are organized in Finland on the digitalization of cross-border judicial information exchange, and especially on the deployment of the new tools for the information exchange, so e-codex and e-EDES and so on and so forth. So the Ministry of Justice has established a project for our national implementation, and for each of the cross-border judicial instrument, and for the different phases, we are planning to have working groups that work with the national implementation. So at the moment we have established, and we are working on the EIO implementation, and I am chairing that working group, and shortly the working group for the service of documents and taking of evidence use cases on civil and commercial matters will start its work, and that's the plan how we will go forward, considering the future timeline for the roadmap for the cross-border information exchange on judicial matters, and on each working group we have participants from the future users, so meaning the competent authorities that will handle and use and execute the certain judicial instruments. So for instance, in the first working group we have our prosecution authority, investigation authority, courts administration, and so on, and part of the task of each working group is to plan and cooperate on the training side, and this is also I'd say the perspective that we came in touch with the TREIO project, and of course in recent months we've had really good cooperation with TREIO and we've had four training sessions for our national authorities. So in the trainings we've had participants from the prosecution authority, investigation authority, courts, meaning judges, bailiffs, legal assistants, but also from the IT service providers. And our national implementation status on e-Codex and e-IDES is that we are still in the implementation phase, and we are hoping that we can go live and finalize the deployment in the second half of this year. But anyway, and apart from that, we still wanted to use the opportunity to cooperate with the TREIO project and give our future users the opportunity to go through the TREIO trainings, and we decided to have the training of trainer method and sessions, and I think the feedback from our users and the future authorities has been really good. The trainings has been considered hugely useful, and the practicality, for example, of the trainings has got a lot of praise and good reviews. Also, I think the discussions and way people have been able to participate and ponder on different things has been found really useful, and also of course the future portal that we will use has been found fairly clear and easy to use, and also the training simulator that also has been discussed in previous presentation has been utilized also here, and I as it was mentioned in for example Dr. Bonici's presentation yesterday, the sessions also have served, I would say, informative purpose, and we have been able to distribute a lot of knowledge and information about the new tool and about the new way of communicating and transferring information in future, and also our participants, the future users, have been able to comment on the new portal and on the new ways of working, which has been really valuable for our national implementation, and we've gained a lot of really good knowledge about peculiarities and maybe challenges that we need to solve out as a part of our national implementation project before we get to the deployment. And based on this experience, I think it's easy to say that our national authorities will surely use the training materials and also the training recordings and especially the training simulator for their own trainings when the time comes for the national deployment, and when the authorities start to have their own trainings and train their staff and future users for the new IT system. So I think as it has been mentioned in many presentations yesterday and today, and as we all well know, the state of the play is that the digitalization regulation has come into force, and also
Sorry, Vari, we cannot hear you anymore.
are something that we need to.
Sorry, we couldn't hear you. You disappear with the audio, but you can start again from digitalization regulation, the first line.
Okay, can you hear me now?
Yes, now yes.
Okay.
Sorry.
Okay. Thanks for the notice. So yeah, I was saying that as it has been discussed in many presentations yesterday and today, and as we all well know, that the digitalization regulation has come into force, and also the service of documents and taking of evidence use cases in civil and commercial matters are something that we also need to start plan how we implement them in our national contexts. And as probably all know very well, the final training responsibility will be on the member states, and also something that has been already, I think, discussed in many presentations is the fact that the reference implementation, the EIDES IT system, will be same for the all future digitalized legal instruments, as it has been for the European investigation orders, and I think many of the member states will at least in the first stage rely on the EIDES reference implementation, and in our national case, it means that the final training responsibility will be on our national competent authorities who will be executing the different legal instruments, and in practice that will mean that dozens of different authorities with fairly limited resources have to train hundreds, if not thousands of future users, legal practitioners, on how to execute the new different cross-border legal instruments in digital form with the new IT system and the reference implementation, and of course that will be a huge task in the forthcoming years. So then giving that background and then starting to look ahead, how to manage the future task on implementing and training the all future legal instruments. I think, and as it has been mentioned in the previous presentations already, TREIO has developed a wide range of modular methods and tools that the authorities in different member states can use for their national trainings, and therefore on our perspective and considering the national implementation, it's of course something that we really much want to emphasize is that from several perspectives it would make a lot of sense that we could utilize the different tools and methods that TREIO and the TREIO project has developed, and for instance the training materials and the simulator and these type of tools that are or I think they could be easily transformed and used for the other future use cases, as well as because we know that the IT system will be the same also in the future use cases, and at least considering the feedback that we have gained from our national authorities and the future users, and because they have found the tools and the trainings really useful and good, it of course would be really good to utilize this work that already has taken place as a part of TREIO. But yeah, that being said, I think I can now give the floor to my colleague Aki, who will go in more detail to our thoughts and opinions on how to go forward. I give the floor to you, Aki.
Thank you, Ivari, for the presentation on the experiences. We have really been taking part in the TREIO training sessions, not only in Finland, but also in Sweden. And we have been able to compare also the reception in those countries, and they have been fairly similar. The attitude of the trainees, so it's been warmly welcomed. Of course, it's much of the gratitude is to the trainers who are present here in the room here as well. I'll be very brief, just saying a few words about the practical steps. So it's the next slide. Can you change, Ivari? Yeah. So what we need to do, as Mr. Postulski was saying, there are 24 instruments to be covered in the training as well, and I think it's very urgent to start planning the new training packages for the new legal instruments, not only in criminal law, but in civil and commercial law, because we will also have new organizations, new users as stakeholders for the systems. Funding is, of course, a crucial issue here. Already last year, the novel project initiative for SOD and TOE was presented, and it was very close to the accepted level, but lacking a bit. And so similar new project initiatives are really needed, and I think for the 21st of March applications, there might be some coming. We really hope so. And of course, the role of EULISA also in the training can be quite useful and essential. And then about the evaluation, of course, we need to see what has to be modified in the TREIO packages for the new instruments. And there is a special case, of course, the European Electronic Access Point, which is part of the horizontal regulation, but it's not as a legislative matter separate as such, but it's something that will be in very extensive use in the coming years. And then, of course, there's the need to have synergies between the different implementation projects so that there is no overlap in those projects. And as Mr. Postulski was also emphasizing, the role of the European Judicial Training Network is very important in coordinating the different training efforts. So these are the conclusions and proposals from the Finnish side. Thank you.
Thank you very much.
Thank you.
I also had good feedback by the trainers that had good cooperation, and it was nice for them to train both in Sweden and in Finland. Okay, so is there any burning question? No? Okay. So we will go forward, and this time we will have the floor, give the floor to Mrs. Marietta Nedelcheva. There, so I will leave Marietta there if she feels more comfortable. And Marietta is a judge of and national contact person of National Network for International Cooperation and the Criminal Matters of Bulgaria, and she will share with us her experience. Please, Marietta, you have the floor.
Thank you very much. Good afternoon, everyone. It's a pleasure and a privilege. I switch on.
Yes, yes.
Yes. It's a pleasure and privilege for me to share my experience with you in the field of the training, how to use the system in practice, which was conducted in Bulgaria in the frame of TREIO Project, and to share some ideas how to proceed forward with trainings. Firstly, I would like to thank to the team of the TREIO Project for their perfect job. My personal opinion as a practitioner and a trainer is that the materials are very well structured and they give the all necessary information about the Directive 2014 on EAO and EAO as an instrument for judicial cooperation from legal and practical point of view. It is obvious that the TREIO team was put enormous efforts to create such a toolkit, which consists presentation, explanation to each presentation, handbook, how to use EIDs in simulation area. The simulation area is very useful because magistrates are trained on the basis of principle learning by doing. In this regard, the TREIO team fully has succeeded to deliver EU-wide standard uniform and practical training and materials on the EAO and its electronic exchange using EIDs. We all know that it is extremely difficult because of the differences between national judicial systems of the EAO member states to do this, but they succeed. Bulgaria was the first country to conduct the online training on June 2022, organized by TREIO Project on the behalf of Supreme Judicial Council. At this training participated approximately 25 judges and prosecutors from all over the country with the interest in the area of judicial cooperation in criminal matters. The presentations were translated in Bulgarian language, so we delivered training in Bulgarian. After the training, my colleagues asked me if it's possible to operate with this system. They were eager to use it. I explained them that it is not possible yet, but soon they will be able to work with it. Till now, I'm sure that my colleagues have forgotten some of the information, so they need to refresh their memories, maybe through follow-up seminars or online meetings. To be honest, I have expected that we will be able to fully operate with EIDs at the latest at 2024-25. Yesterday, as I was devastated when I heard that it will be possible at 2028. It is the very long period of time in my point of view. We are moving very slowly in the comparison with the development of technology and the activities of criminals. I said criminals because as I'm a criminal judge and my expertise is especially this area. I would like to highlight that I fully agree with Tonia's conclusion raised in her presentation concerning the implementation of EIDA system, because in Bulgaria we identify the same advantages and disadvantages of the system as in Greece. For example, in Bulgaria we have too many issuing authorities and they need accreditation. It is not clear who will work in Bulgaria with this system, but maybe this problem has to be solved on the national level. Also, problem is an electronic signature of the EAO, and also we don't have a solution how we will transmit the classified information through EIDAS. After almost a year from the first training through April 2023, National Justice Institute of Justice in Bulgaria organized on the proposal of Supreme Judicial Council, which is a partner of TREIO Project, online training, European and national legal framework for the EAO and the observance of fundamental rights. I would like to point out also that the project TREIO provides guidelines on the adoption and customizing of the training materials to different jurisdictional contexts and legal specifics and procedure taking place on the national level. I use these guidelines in order to deliver online training through April 2023 of the EAOs and EIDAS to Bulgarian magistrates. From my point of view, it was very easy to work with the materials, customize them to Bulgarian law, and to deliver the training together with my colleague prosecutor from the District Prosecution Office in Plovdiv. The training that I mentioned aimed to provide Bulgarian magistrate judges, prosecutors, investigators, judicial and prosecutorial assistance with theoretical and practical knowledge on the legal instrument for international cooperation in criminal matters, especially EAO. The methodology of work included, as I said, theoretical and practical part with two models. First model aimed to provide participants with self-learning materials presenting EAOs in accordance with its provisions in Directive on EAO. The essence of the legal instruments, its scope, the basic principles of the four phases of the EAO's existence, the issuance, sending, recognition, and execution of the legal instrument. The second model was dedicated to the legislation of the Republic of Bulgaria and the case law concerning the issuance, sending, recognition, execution of the EAO, and the application of the legal instruments to various investigation measures at national level in the light of respect of fundamental human rights. In this model was represented an EIDA system as using material prepared by the team of TREIO Project. I would like to emphasize that the Supreme Judicial Council has provided National Institute of Justice with all materials from TREIO Project and the audio recording of the trainings on June 2022. A lot of materials were translated in Bulgarian and the materials were uploaded on the website of National Institute of Justice, and magistrates have the access to them through their profiles for self-learning. I represent a Bulgarian experience concerning trainings, and now I'm moving to the point what has to be the way forward. It turned out that according to information from colleagues from EU member states, some of them have no information at all about the work of the TREIO project and the electronic platform for exchanging EAOs and requests for mutual legal assistance, EIDAS, that That is why it is necessary to raise the awareness of judges, prosecutors, investigators, and staff about the existence and way of working with this system, and popularize TREIO trainings and their great advantages, such as user-friendly and intuitive system, EIDAS, a significant reduction of the cost of interpretation because the machine translation and time of the issuance, dispatch, and execution of EAO. I think that this can be done through common work between EU Commission, EGTN, European Judicial Training Network, the national training centers for magistrates of the member states and their prosecution and judges councils, or the Ministry of Justice, depending on how the judicial system of each country is arranged. Centrally, that information can be disseminated by organizing EGTN trainings on the application of EAO, not only from a substantive and procedural point of view, pursuant to a directive on EAO, but also by training in the use of EIDAS system using TREIO materials. The two models, substantive law and practice, can be combined into one training, and the practice of Court of Justice in this area also, it is important to be presented. Case studies can be taken from this rich practice of the EGN and Justice and Eurojust. It is important to include at the trainings other topics as improving IT skills of judges, prosecutors, and the administrative staff, electronic evidence, artificial intelligence in judiciary, and admissibility of evidence, etc. I will give you an example for one successful training which was conducted on 5 to 6 October in Leipzig, Germany, and the subject was EAO in practice, focused on the preparation of EAO in digital form and usage of EIDAS in practice. In this respect, I would like to emphasize the importance of the personal contacts between practitioners of different member states. These trainings will bring practitioners together and give them the opportunity to exchange experience and good practices of the application of EAO and implementation of EIDAS and the digitalization of the judges. The usage of the other learning methods like online training, self-learning courses, hybrid trainings are also possible, but maybe more efficient method of training is participants to be present in person and interact each others. Thank you for your attention.
Thank you very much, Marietta. Thank you very much for your feedback. And I'm also happy to hear that the feedback is part in favor of traditional, part in favor of online, simulator. So it means that what we think is true. We have to, we don't have to suggest to member states a strategy, because every member state has to have the possibility to choose its own strategy and to do the training with the tools that are available and are modular. So you can choose what strategy you want. You have the tools. Okay, so the very last contribution, and this is a heavy responsibility, Yves, because you have to close the session and the conference. So Yves is one of the partner of the TREIO project. He's from ECTEG, and ECTEG was the one that developed the e-learning for TREIO. So Yves has the task now to show us how this technology, because it's part mainly technology with content, can be transferable.
Thank you, Maria Angela, and good afternoon to everybody. I took notes, and also ECTEG did it, but the real person, that's Georgina, who presented e-learning product yesterday, who did, yes, the most of the work. I'm here on a bit more to explain the way forward. And I was especially concerned by the comments from Teresa and from the Commission about what you're expecting, and I think that I can give you some good news. Or not. So I will focus on the on deployment and sustainability. Just I'm a bit like a bit the cat in the box because it's I'm an ex-cop, so police officer and IT forensic experts. So that's probably not we are speaking different languages, and that's also a discovery during this project, because in the evidence project, I was supporting your project by giving the feedback from the point of view about digital forensics and so on. And ECTEC is developing training materials for the law enforcement and mainly for the people specialized in digital forensics. So the effort in the TREIO project was using the same platform, using the same processes, but for a totally different audience. Although we are fighting on the same side of the force. To understand what's possible now and what will be possible in the future, it's very important that you understand that we have two different parts in that process. First, we have the development side. And on the second, on the right of the slide, it's your unit, your entity, your country, your Ministry of Justice or whatever, where the e-learning may be deployed. So how it works, we are using something which is an open source product, but that's one of the most powerful, initially developed for the scientific academy in universities. For a lot of reasons, it allows collaborative working and also something which we named the derivation. So everything starts with the main version. That's the English version that probably Georgina made the demo yesterday, or very short demo, or very sneak peek on it, but that's the concept. So that's important because that's there where the content is validated by the experts, so meaning by the people who know what I am speaking about, because the platform is totally stupid. So when it exists, you can make derivation, and the derivation can be at multiple levels. So for instance, for TREIO, we limit that to one level, which is the translation. But that's not only a translation that is possible, that's a localization is possible. So for instance, for law enforcement, and that's a bit addressing the request about understanding digital forensics and all those things pointed by Teresa at the beginning of the panel, is that, we provide additional things like templates for the interrogation of the victim, but also contact number in case of emergency. And you can understand that, for instance, the French colleagues will not call the Belgium units to ask for support in case of emergency. But more than that, you probably know the landscape, but the French gendarmerie asked to have a different version with the French National Police. And we stop at that level, but this is an infinite way of working. But it means that the product can be totally different for each country, still keeping, like a backbone, links to the motor version, which allows to add new content, to update based on the evolution of the criminal context, the law, for instance, adding some jurisprudencia, which may be interesting for everybody. And automatically, when something is added in the main version, it is sent to all the derivation. Now, not yet translated, but once the product exists, the work is quite minimal to address the small updates. Once the product is ready, and it can be a cycle, For instance, for the product that I spoke about, it is every 6 months. We generate it, and then it can be installed into institutions. So for the people who make the test, they connect on the ECTEC model, which is a learning management system. I suppose, for instance, that EGTN has the possibility to run some similar infrastructure. But that's not mandatory to use that. And to give, again, the example of the other product, thanks to the translation and the support from the BKA, the product is now directly accessible by all the police officers in Germany from their computer. And I think that 1 week after, the prosecutor office in Germany asked, can we have access to it too? And why not? Because there is something confidential, but again, that can be shared to allow the partners in the fighting of crime to understand what they are speaking about. And something which is more important for me, to allow the prosecutor to be the leader of the investigation, asking to the people, don't you forget to do that, because I think it's possible. So that's the type of things that was quite easy to do, because for the BKA to deploy it, it is around 15 minutes. Obviously, the translation in German needs to exist. And then you have a third version, which is the PDFs. Now, looking to the different, that's something that has to be mentioned when you go to the translation. There are some issues. For instance, if you put text in images, the image has to be rebuilt in the new language. That's why, by design, we have to think about it will be translated, and there are ways to avoid such, I would say, slowdown in the translation or localization process. So for the formats, HTML version, you can install it in every institution where there is a portal. It takes 15 minutes. Advantage is that you have the direct access. Disadvantage is that you cannot monitor the progress of the, let's say, student. Now, speaking about the other product, and I think it's perfectly doable for TREIO, the advantage of this approach, it is not only a course, it can also be used as a reference base when you can put a keyword and immediately getting the ranked by the number of times that the keyword is coming in each page, giving access to the information, which can be also improving the quality and the efficiency of the work. The second way to implement it is what we named the SCORM version. There is no many difference, that's only a format. SCORM is recognized by all the learning management system in the north of Europe. They are mostly using Canvas in all universities, and Moodle is quite usable too, and it's totally free of charge for institutions. CPOL, for instance, used to lead, and I suppose that EGTN is using something similar. Deploying time is exactly the same. The difference is that thanks to the SCORM, there is an exchange between the learning management system and the e-learning package, which allows to be informed about the progress of the student. I have to say that the most recent version of SCORM is named SCORM 2004, which is the date of the last version, meaning that compared to what we can do in the e-learning package, SCORM is quite limited in terms of amount of variable and so on. In theory, we will be able to follow step by step and knowing how long a student, no, don't discuss about GDPR, it's not, how long did a student spend time on that part of the course and so on and so on. Obviously, the EDS simulator, and many of you pointed it, is something that has to be accessed separately. It's another system. Now, we can look to an integration, but instead to integrate the EEDS in the TREIO, in the e-learning, perhaps is it to integrate the e-learning in the simulator, which technically is perhaps easier. Then you have the PDF version, so which is you can print it, you can read it as a PDF document. Obviously, no video and so on. If you have exercises are still there with the solution. Like when you make the crosswords, you look at the end of the book and you have the solutions. That's the same for the PDF version. So about translations. At the moment, humans are translating. So don't dream, humans are still very useful, at least to translate. As I already spoke about the possibility to improve the standards, to facilitate the process of translating. And obviously, after the end of the TREIO project, the ACTED platform is still there. We are funded by DG Home, sorry for DG Justice, but I think that we are fighting for the same things, and there is no cost related to the access to the platform. Now, because TREIO is not the only project running on that platform, we have more than 40, 45 courses developed, and for some courses, like the one for the first responders, we cannot deliver that only in English, because that makes sense that a police officer in Italy doesn't speak English so good that he can follow a course, so they need that in Italian, for instance. So at this stage, for the other product, we have 12 EU languages translated manually, but we are in a process to integrate a translator engine using artificial intelligence developed by the French Gendarmerie, and the model is trained by Europol, meaning that you know, all those jargons about IT, about electronic communication is something that the model is already able to translate quite efficiently. We made tests, and with the support from the Swiss German-speaking police, and it is quite impressive. Now, that requires a review from real humans, expert on the topic, not only to be sure that the final version is in a good quality for the language, but also to improve the training of the model so that later translation will be also improved. So what is important when you get EU money, and you spoke about it, is that when a project ends, sometimes the project dies. I saw Georgina sweating on developing the things and trying to make something as best as possible. I don't want to see something dropped after seeing so much quality work done by colleagues. So at this stage, you can get the e-learning. It is only to require it, contacting the TREIO project, and we will provide for the language which are available. But obviously, we are maintaining it, so meaning that when the platform evolves, the product automatically evolves with improvement, for instance, on the user interface, and so on and so on. Everything will continue because it's something which is included in the concept when we create that contribution in the TREIO project. Let's say that is a bit of kinetic progress. Now that the things are running, it's quite not difficult to maintain it. However, if we want to add languages, we will need help. And for the artificial intelligence connection, it will require a bit of work, but we need to do it anyway for the other projects, so you will benefit of that improvement when it will be available, I expect in the middle of this year. And yes, still obviously keep alive the simulator, because that's also a good piece, because for instance, when I speak about the first responder for law enforcement, we have serious games. And Teresa, you pointed the fact that the people need to practice to understand and to integrate the knowledge, which is one of the basics of the pedagogical approach. And I think that the EDS for that specific AEO is something very important. So again, obtaining it, if the language is available, it will be quite straightforward. If the If the language is not available, you can guess the question is, do you have somebody who will be able to be happy or not happy, but who will be able to contribute to the translation? And yes, the installation, I said 15 minutes. There will be a hands-on or manual for the installation. And in case of required, we can also have remote support for the installation. Or if somebody in the Bahamas want to run TREIO, we will be happy to do that on site. Echo, I think that that was the end of my presentation. But you liked a bit because you are the one making the conclusion. Thank you.
I saw that you were distracted while presenting, thinking about, it's me that I have to close this meeting? No, okay. So thank you very much. Is there any question to Yves? No? Okay. So I think we are all a little bit tired because we had 2 tough days. And let me sum up my keywords from yesterday. So we started saying that keywords were justice, community, knowledge, awareness, trust, training, and then we have added cooperation, digitalization, innovation, flexibility, mutualization, testing, and the adjective to the training, lifelong training, fertilization. I want to close this meeting first of all, thanking all of you that came here, spent these 2 days in this room without escaping for shopping or for other activities, and for having paid attention to all the presentations that have been done, because I see a lot of interaction. My main I would say my main happiness comes from the fact that once the session were closed and we went out for coffee break, for lunch, I had people talking about the topic that was discussed in the room. So for me, it was like, oh my God, this is what we want to achieve. This is what we wanted to spread the word, to build the awareness and the trust and the knowledge among these themes towards the need and the importance of the training for producing the change. So I will give you, I will steal a phrase from Fabrizia from this morning, and then I will go to the formal thanks. I will leave this conference saying, involve me and I will learn. This will be our aim for the future, to think about the right adjustment to the strategies that we have put in place in order to involve practitioners, involve those people that need to be trained, because if they are involved, they learn. If they are not, they don't feel involved in what we are trying to communicate, they will not learn, even if they are online, in a room, or whatever you want. So, thank you very much to all of you,